is in plaintiff's side litigation. She teaches a lovely seminar called The Plaintiff's Lawyer, and in that course last year dealt with some of the various topics in this litigation. So I think she will be an excellent moderator for this discussion. So thank you.
Great. So as Matt said, I do teach a professional responsibility class here at Stanford called The Plaintiff's Lawyer. And during the quarter, we study, the model rules of professional conduct, and I end the quarter with a series of case studies I've developed that force the students to synthesize and apply the many rules we've learned. So my view is if they can handle the case studies, then they've mastered the rules and the material. And last year, our final case study of the quarter was the Chevron case. And I picked this case as the final topic because, frankly, I consider myself a pretty creative, imaginative writer of hypos, but not even the most diabolical law professor with even the broadest poetic license could possibly devise a set of facts that raises many complex, important, and difficult ethical issues, including everything from the extraterritorial application of our rules to the precise terms and exceptions of the attorney-client privilege, to the role of third-party funding in litigation, as we talked about in our last panel, to the very question of what it means to be a lawyer, a zealous advocate, or public citizen. In addition, a theme of the course is who are plaintiffs' lawyers? Are they private attorneys general, willing and able to hold companies' feet to the fire when those companies misbehave? Are they public interest lawyers, devoted to serving the interests of the society, including those less fortunate? Are they parasites who jeopardize commerce and feed off the productive class? Or are they pariahs operating at the edge of law and toiling at the bottom of the professional hierarchy? So answering that question is difficult yet important, and it is hard to imagine a case that more starkly exposes the tension and the overlap between those dueling conceptions as this litigation. So those will be the questions our panelists help us to confront over the next period of time together. So kicking off our discussion is Patrick Keefe, author of the brilliant New Yorker article, Reversal of Fortune, which I assigned to my students, and I think we're going to get to hear him talk about. So Patrick is a graduate of Yale Law School and currently a staff writer at the New Yorker, and a fellow at both the Woodrow Wilson International Center for Scholars and the Century Foundation. So he will set the scene for us today. Next, we'll hear from Morris Ratner. Morris is an associate professor at UC Hastings, where he teaches both ethics and procedure. And before becoming an academic, Morris was a partner at San Francisco's Leaf Cabraser, one of the most highly respected plaintiffs' firms in the United States. And finally, we'll hear from Catherine Rogers. Catherine is professor of law and international affairs at Penn State. Her scholarship focuses on the convergence of the public and private in international adjudication and on the reconceptualization of the attorney as a global actor. So her book, Ethics in International Arbitration, is due to be published later this year. So with that, I'll turn it over to Patrick.
Thank you so much, Nora, and thank you to the organizers of this terrific symposium. It's been fascinating. I was an incredibly indifferent law student, so the irony of being invited to speak at a law school is one that I relish. Instead of becoming a lawyer, I became a journalist, and I wrote this article, which came out about a year ago, about this case. And the original title of the article was actually not Reversal of Fortune. It was the title that I chose, which was rejected at the last minute, was Zealous Advocacy, which feels like an appropriate theme with which to begin today. I thought it was funny that the editors at the New Yorker at the last minute decided that zealous advocacy was sort of too abstruse a concept for readers of the New Yorker to grasp, so they went with the more banal Reversal of Fortune. Made me think about the kind of anthropological differences between journalists and lawyers, something I often have occasion to think about. A recent example of this, which I thought you might appreciate, is this art. Some of you may have seen it. The New York Times did a big profile the other day of Sonia Sotomayor. And there was this line buried in the piece where they talked about how she had been plucked from circuit court obscurity, which I thought was great. You know, the wilds of the Second Circuit, Siberia. Because I'm a journalist, I'm very interested in stories. but also in facts. And one of the interesting things I found about this case, and the fact checkers at the New Yorker found, is that there are more stories than there are facts. That almost everything that might seem like a fact ends up being disputed. I could give you many examples of this. There was a monk who, from Spain who moved to Ecuador and spent years, he moved in the 60s and spent years working with the tribes in the jungle, and he told me when I went to interview him, in the jungle there is more literature than history, which I thought was a useful kind of admonition for me. I could give you examples of this. My favorite is that, at one point the plaintiffs commissioned a scientific study which found that in the Orient there were higher rates of cancer than there are elsewhere in Ecuador. And Chevron then commissioned its own scientific study, which found that not only was it not the case that there were higher rates of cancer, but in fact there were lower rates of cancer in the Orient than there were elsewhere, that you were less likely to get cancer if you lived in the affected area. Both sides have PR teams, and some of you may be on the receiving end of these emails. I actually kind of enjoy it. Every week or two I'll get an email from one side or the other, and you have these kind of claims and counterclaims, many of them involving misconduct of one sort or another by the lawyers. And I'm just going to read you just so you have some sense of what these emails are like. This is from just almost at random, last March 15th. Chevron uses espionage against lawyers who won $18 billion verdict in Ecuador. Urgent measures sought to protect physical security in light of threats, surveillance. That's from the plaintiffs. 3 days later, Chevron. Judge who issued $18 billion ruling against Chevron removed from the bench. July 24th, the plaintiffs. Chevron lawyers fleeing Ecuador case as company's losses mount. September 26th, Chevron. Chevron claims patent bogs tried to cover up a fraud. And then just recently, January 28th, Chevron. Former Ecuadorian judge admits role in orchestrating fraudulent judgment against Chevron. 2 days later, the plaintiffs. Chevron's new Ecuador witness linked to drug traffickers and bribery attempt. My favorite, actually, of these emails that I got in the past year was from March 19th. The New Yorker missed the real story on Chevron's Ecuador disaster. That's from the plaintiffs. It's a pity that Stephen Donziger isn't here, because another thing that we could talk about is the extent to which, while there are matters of law and procedure and jurisdiction that play into this case, personality does in a big way too. And having spent a great deal of time last year with Stephen Donziger, this made a very strong impression on me. What I found when I went to Ecuador and spent time with both sides is that corruption in a country like Ecuador, and corruption is real in the judiciary there, has a logic. It has a kind of a game theory of its own. And I started to think of it as a bit like doping in athletics, that if you're a lawyer and you want to zealously make your case, and you're doing so in a jurisdiction where either it's true or even if just you believe that there is a great deal of corruption, the temptation may be there to start transgressing a little bit out of a fear that if everybody else is transgressing and you're not, and you try and be upright and you try and respect the ethical rules that would govern you in the United States, that you might actually be doing a disservice to your case and your client, putting yourself at an insurmountable disadvantage. So I found that for me, this put me in a strange position, because in some ways, if you look at the underlying merits of this case, I'm quite sympathetic with the plaintiffs, having been to the Orient, having gone to the pits. To me, it is not satisfying that Chevron did a $40 million remediation. If you look at the facts on the ground, I feel as though there are some respects in which the plaintiffs have a kind of moral authority. At the same time, in order to make their case, in order to prevail in this case, the plaintiffs took steps which I think squandered that moral authority in a number of ways and may have fundamentally imperiled their own case. The saddest feature of this whole spectacle to me, and this is the note that I'll end on, is that it could have settled, is that there have actually been a number of junctures over the last 2 decades when the case has almost settled. One thing I describe in the article is that in 2001, just before the Texaco-Chevron merger, the plaintiffs went to Texaco with an offer saying that for $140 million, we will drop all of our claims. And Texaco walked away from the deal. And Today, if you talk to the plaintiffs, they will say that that was too low a number. We never should have accepted that. I would imagine if Chevron looks back at that incident, they have a slightly different feeling about it. The plaintiffs today estimate that Chevron may be spending as much as approximately $140 million a year just to try this case. I've gotten no confirmation from Chevron on that or Gibson Dunn, but if anybody would like to be forthcoming, you know where to find me. I think that ultimately the case probably will settle, and yet I've been saying that now for the last couple of years. I thought that before it got to a point where the plaintiffs started trying to collect in various jurisdictions around the world, the case would settle. I don't think anybody wants that. And so here you have this kind of bizarre reframing of zealous advocacy where the two sides are so pitted against one another and there's so much enmity that in some ways I think they're doing themselves and their clients a disservice by belaboring this to the point that they have. And we're left, to use a word that somebody used this morning, and I think you're going to discuss later, in a kind of quicksand, a morass from which it's hard to see any possibility of escape. Thank you.
Okay, so my comments build pretty directly on Patrick's description of the allegations of misconduct by the lawyers involved in the Chevron litigation. I'm asking two questions, both of which are fairly doctrinal. First, in a case like the Chevron litigation, where a judgment is obtained in a foreign, non-U.S. tribunal, is it clear what body of ethics doctrine a U.S. disciplinary authority should apply to evaluate the lawyer's conduct? And if not, what are the likely sources of ambiguity? And then second, the other question I'm asking, I think, flows from the first and is very similar to the question that Howard Erickson actually asked earlier this morning, which is, if, as I believe is the case for the most part, model rule of the ABA, Model Rules of Professional Conduct 8.5, which governs choice of law and multi-jurisdictional practice, if that rule imagines application of a foreign jurisdiction's ethics rules for conduct connected to a foreign tribunal, is there a limit on the extent to which a U.S. lawyer can play by foreign rules that offend our most basic professional values? I should note I'm not asking these questions in a vacuum. There's some excellent scholarship that already touches on these topics, including a wonderful article by my co-panelist, Catherine Rogers, who wrote in 2009 an article, Lawyers Without Borders, in the University of Pennsylvania Journal of International Law, and an article from 2000 published in the Georgetown Journal of Legal Ethics by Detlef Vatz, who spoke to some of these same issues. So the Chevron matter is typical of a particular species of transnational litigation, which I think is important to define before I delve into the answers to the questions themselves. For want of a better term, I label this politicized global mass torts, common features of which include, number one, underlying alleged misconduct by one or more corporate defendants, which takes place mostly outside the United States, but which has some nexus with the U.S. that's sufficient to generate the participation and interest of U.S. lawyers. Second feature of these politicized global mass torts is extended case timelines. The Chevron litigation is coming up on 20 years, often associated with battles over jurisdiction, venue, discovery, and now the enforcement of judgments. A third feature of these politicized global mass torts, more than one tribunal at any given time may be involved in these matters, either at distinct procedural moments in the life of the case or at the same time. So for example, while the parties in the Chevron case in Ecuador were inching towards a judgment, they were also litigating discovery issues in United States courts, and there were arbitration proceedings occurring abroad. And finally, fourth, there is a perception that I think actually the defense counsel mentioned earlier today. There's a clear perception by plaintiffs' advocates of the litigation as one component of a larger social movement or cause, which involves multiple branches of government and different kinds of advocacy in addition to what we normally think of as lawyering, including lobbying, community organization, public relations, all directed at multinational corporate defendants facing very large potential liability, the sheer scale of which heightens the sense that there's a political or extrajudicial dimension to these politicized global mass torts. So the first question I posed is, as to this species of transnational litigation, these politicized global mass torts, from the vantage point of a U.S. state bar's disciplinary apparatus, do we know which body of ethics doctrine applies? And if not, why not? The choice of law question is a critical one. Let's just take as the conduct in question two types of behaviors alleged to have occurred in the Chevron proceedings. First, I think Patrick's New Yorker article and Judge Kaplan's order from March of 2011 describe a cluster of behaviors, including community organizing, political lobbying, and public relations, all aimed at influencing the judge's decision in the Ecuadorian case. If U.S. ethics rules apply, such conduct could be seen as a violation of, among other rules, Model Rule 3.6a, which prohibits extrajudicial statements aimed at materially prejudicing an adjudicative proceeding. On the other hand, if Ecuadorian ethics rules apply, the conduct is unlikely to be deemed unethical. Where I'm informed by the lawyers who regularly practice in Ecuador that neither the code in place at the time of the conduct in question nor the current codes by which Ecuadorian lawyers consider themselves bound prohibit that kind of extrajudicial public relations campaigning unless it involves direct threats to a judge. Similarly, Patrick's New Yorker article and Judge Kaplan's orders describe efforts by plaintiffs' counsel to reinforce the impression, which we heard about earlier today, that Richard Cabrera, an expert appointed by the Ecuadorian court, was neutral and independent, when, according to Judge Kaplan, he was anything but. Judge Kaplan's perception being based in large part on ex parte contacts between the plaintiff's lawyers and the court-appointed neutral. That conduct clearly violates a number of ethics rules in the United States, including most prominently Model Rule 3.5, which prohibits ex parte contacts with judicial officers. And to the extent there was some sort of cover-up, the model rules that prohibit dishonesty and deceit. In Ecuador, at the time of the conduct in question, it's important to understand that ex parte contacts were completely permitted. So it's much harder to make an argument that under the ethics rules in place at the time, there was a violation of ethics rules. So we have a clear conflict of ethics regimes, which Model Rule 8.5 is designed to address. Model Rule 8.5b is the choice of law provision in the model rules, which helps us resolve exactly these types of conflicts of law. 8.5b1 states quite clearly that for conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits, unless that tribunal's rules provide otherwise, are deemed to apply. So in this case, Ecuadorian ethics rules, according to the plain language of 8.5b1, are deemed to apply. There's another provision for conduct unconnected to a matter pending before a tribunal, but I don't think that one applies quite as clearly. So is it clear that Ecuadorian ethics rules apply to determine whether the plaintiff's counsel's conduct in this case is sanctionable or warrants discipline? One answer is yes, pursuant to the plain language of the text I just read. I think there's at least three reasons to complicate the answer to that question, which I'll review. The first complicating factor and possible source of ambiguity is the determination of the location of the tribunal. Where is the tribunal in transnational litigation that spills across borders? For example, in the Chevron case, is it the location of the Ecuadorian court that issued the judgment? What about the connected proceedings in the United States involving discovery disputes? What about proceedings to enforce the judgment in other countries? One view is, and I think this is actually probably the dominant view, litigation can be imagined as a series of disconnected procedural moves where the tribunal is the court ultimately responsible for the resolution of any one move. So the Ecuadorian court is the tribunal for purposes of activity that relates to the judgment itself, and then we would separately examine and put in a separate box conduct that occurred in the United States with respect to discovery disputes. The virtues of this view are that it seems consistent with the intent of Model Rule 8.5 to give clear guidance regarding choice of law in multi-jurisdictional practice and to level the playing field so that U.S. lawyers practicing abroad could play by the same rules as foreign lawyers. I think the chief disadvantages are that it suggests a division between procedural moments that feels artificial. For that reason, it seems particularly ill-suited to the kind of multi-jurisdictional practice that the Chevron case typifies, where more than one jurisdiction or tribunal may be the venue for some component of the case at any given time. Each procedural juncture has ripple effects with respect to other procedural junctures, and all of the players expressly conceive of the litigation in terms that transcend any one jurisdiction. A second complicating factor and possible source of ambiguity in applying Model Rule 8.5b1 is defining conduct. What is conduct in connection with a matter pending before a tribunal? There's a narrow reading of the phrase. The New York version of Model Rule 8.5 actually gives life to that, which is just conduct by lawyers admitted to a particular tribunal that advances the aims of that particular tribunal towards a movement towards a judgment. There's a much broader reading, which I think the plain text of the model rules also makes a reasonable one, which is that any conduct undertaken in a foreign jurisdiction that relates in any way to a judgment in that jurisdiction is covered by the home rules of the tribunal, in this case, Ecuador. The reading we adopt obviously matters, and I don't think there's a definitive answer as to this potential source of ambiguity. The third complicating factor and possible source of ambiguity in applying Model Rule 8.5b1 is defining what we mean by the rules. When it says in this choice of law provision that for conduct in connection with a matter pending before a tribunal, we apply the rules of the jurisdiction in which the tribunal sits, what rules are we talking about? So in Ecuador, for example, the rules are in flux. The rules are not an analog to, a precise analog to, the ethics rules that we have here in each of our jurisdictions that govern lawyers. Moreover, I think it's critical to examine not only the formal text of the rules, but the rules in application. How are they enforced? Are they simply aspirational, or are they actually considered the law governing lawyers that's intended to bind us to a particular code of conduct? In Ecuador, the code that was in place at the time of the conduct in question in this case was rarely enforced. The harshest sanction was a temporary suspension. There was no disbarment of attorneys for violations of the ethics code in question. And the usual sanction, to the extent there was one, was a very modest monetary penalty. So when I've talked to lawyers who practice in Ecuador and asked them what ethics rules govern your conduct, the typical answer I get is, I'm not aware of any ethics rules, because most of the lawyers in Ecuador don't pay attention to it, given the fact that the enforcement regime is so weak. So there's a number of reasons to doubt whether Model Rule 8.5b1 gives clear guidance regarding the ethics rules to be applied to conduct occurring abroad in the kinds of politicized global mass torts which have been the subject of my remarks so far. But despite these potential sources of ambiguity, I think the most straightforward reading of the model rules, at least, points to the application of Ecuadorian ethics rules to the conduct in question here, which then leads me to my second and last question, which is there a limit to the extent to which U.S. lawyers can play by foreign rules that offend our most basic professional values? I think the most persuasive arguments in favor of a relatively straightforward application of Model Rule 8.5b1, which simply applies the foreign jurisdiction's ethics rules without limitation, are that number one, that kind of reading is faithful to the plain text of the model rule, and number two, any project to map the boundaries of what would amount to a limitation on or exception to Model Rule 8.5b1 gets us into the sticky and messy project of figuring out what our core values are exactly. What are the values that we cannot violate, even if a foreign jurisdiction would tolerate the conduct in question. I think there are at least two fairly strong counter-arguments in favor of recognizing the possibility of discipline at home for conduct that is governed and tolerated by a foreign jurisdiction's ethics rules. First, the what happens in Vegas stays in Vegas approach to Model Rule 8.5 that a plain textual reading gives rise to ignores the possibility that what happens in Vegas changes the person who's vacationing in Vegas, and in a way that calls into question one's moral fitness to practice at home. And second, as to the difficulty of the project of mapping the boundaries of any limitation on or exception to Model Rule 8.5, there's already at least a dotted line around certain behaviors that we do not tolerate. One such dotted line can be found, for example, in Model Rule 8.4 that prohibits dishonesty or deceit, even in actions completely unconnected to traditional lawyering. For example, if a lawyer is engaged as a citizen, not as a lawyer, in a business transaction and engages in fraud, that lawyer can be disbarred as being morally unfit to practice. And similarly, U.S. courts have long exercised the inherent authority to deem attorneys unfit to practice law when the conduct so warrants. There's one fabulous little nugget of a case that I ran across called Ex parte Cole from 1879, before we even had a set of ethics rules, where the conduct in question really tracks the conduct in question in the Chevron case, where a lawyer was accused of making public statements intended to place pressure on a judge to decide a certain way in a case. And that lawyer was disbarred, even though the conduct was legal, because it was deemed to be conduct that called the lawyer's moral fitness into question. So the courts do have that inherent authority. So in summary, I think it's possible to both adopt a textually faithful reading of Model Rule 8.5b in connection with these politicized global mass torts, and at the same time protect our most cherished professional values from being violated by lawyers who are engaged in practice in foreign jurisdictions.
Thank you. Those are two hard acts to follow. So I'm going to try and go a little more broad, perhaps, than the earlier commentators. The title that I've tentatively chosen for my talk and the essay that'll follow is When the Bad Guys Are Wearing White Hats. I am, as it suggests, focusing on essentially allegations of misconduct by plaintiff's counsel, in this case excluding Judith, very prominently. Now, I do tend to agree with some of Professor Newborn's comments earlier today that there might be some interesting allegations of misconduct, and also cited in some of the titles that Patrick commented on, by defense counsel. But to some extent, those seem less inherently interesting. None of them had mustaches today, so you can understand that I'm speaking by metaphor. But when we hear that lawyers for a big multinational extractive industry, are twirling their mustaches as they engage in conduct we think is unethical, we're just like, oh, well, who cares? But when it is the people wearing the white hats, we do seem much more concerned about it. And what I want to do is talk about what are, I think, the conditions, the preconditions that create a sort of ethical quicksand, particularly for plaintiff lawyers, in these kinds of cases. And so my starting point is that there are essentially two main pillars to professional ethics for lawyers, and we know them all. One is loyalty to your client, and the other is your obligations as officer of the court. And the problem is when you put these pillars in quicksand, they don't hold anything up. So I'd like to go back through both of them and then end with some larger observations about the rule of law. But with regard to loyalty, and we had some really, I think, interesting comments this morning from Professor Reddish about what I think erodes, essentially, this general obligation of the affirmative obligation that lawyers have of loyalty to their clients. And in particular, what was identified is they have a larger financial interest in the case. And so it creates a sort of risk that they might undervalue or bargain away some of the loyalty that they otherwise owe their clients. And I think that's classic in any class action situation, but I think it is much more pronounced in these kinds of cases. Why? Because the nature of the geographic, the cultural, the linguistic, the historical difference, I think, adds an additional layer of problem to the watered down loyalty problem, and that is the inability of clients to hold their attorneys accountable for exercising their loyalty. So in the United States, with class actions, the same sort of attenuation of the loyalty obligation occurs, but there are malpractice actions. There are bar disciplinary authorities that, while not always as responsive as we think they should be, most clients know, even if they're relatively unsophisticated, that they can call and complain. The idea that an indigenous plaintiff down in Ecuador would ever be able to do that, I think, is highly untenable. I also think that clients, obviously the less sophisticated, the more difficult, but they provide a monitoring function. The idea that very culturally distinct, linguistically challenged, people on the other side of a linguistic barrier, many countries away, could ever operate with that sort of monitoring is hard to imagine. And so I think that one of the primary pillars, and in fact the main pillar in the U.S. system of loyalty is very much at risk when you have this kind of transnational litigation. Let's look at the other pillar, the obligation that lawyers have to be an officer of the court. One of the things I found fascinating when I kept reading about these various accounts of what was happening once the case had been dismissed from under forum non back down to Ecuador was that Donziger kept being described as the lead counsel, but he was not. He was not counsel of record in the Ecuadorian court. He was actually, at least for some period as I understand, counsel of record in no court. So I take very much to heart Professor Hensler's comment earlier that of course these cases not only involve litigation strategy and activity, but also a political element and a publicity element. But what if you take away essentially that tether to the court system and all you are doing in a sense? I mean, so it's not sort of by accident that it seemed to be from some of the quotes we heard earlier this morning that that was how he was perceiving his role, because in fact, at a very technical level, he was not an officer of any court at that time. And I think this is also revealed in one of the quotes that was not quoted this morning, but I found sort of revelatory in its negative implications. So there was a comment saying, at one point he's talking about he's going to use intimidation on the judges, and then the following sentence, which was not quoted this morning, is he says, as a lawyer, I never do this. You know, the negative implication being, right now, I'm not acting as a lawyer. And I think that seems to be, when you look at some of this conduct, perhaps how he perceived himself. Now, why is it important that somebody be, at a technical level, an officer of the court? It's because you actually know that if you engage in misconduct, the court can hold you accountable. You can get in trouble. And interestingly enough, in the email we saw, the lawyer from Ecuador was complaining that your lawyers down here in Ecuador might go to court. But it didn't seem to suggest that Donziger was going to be held accountable either in the Ecuadorian legal system. And so I think that, so we can talk about, as a choice of law matter, which rules might apply. But to some extent, the major pillar on which those rules are constructed around is missing in a very tangible sense in this kind of case. And that brings me to a larger sense of why we have this notion of officer of the court. And that is because lawyers function as a mechanism for upholding and reifying a system of laws, the rule of law, in the system in which they operate. And that is another factor, I think, here that's sort of missing and that creates particular risks for attorneys involved in these cases. And that is the circumstances under which these cases arise are very much shifting political sands. And I'm not talking about sort of the background idea that, in developing legal systems, the rule of law might not be firmly enough entrenched, or, you might not have, the level of judicial independence that we appreciate and expect in this country. And I'm talking about something in some ways a little more specific to these cases. First of all, in the Chevron case, as in the Nicaraguan case with Dole, as in the Bhopal case, in each of these instances, there was no such thing as class actions in these systems before the government specially created, through legislation, the class action mechanism that was available for these plaintiffs. Now that's really radical if you think about some of our discussion this morning about how complicated a class action is. And in fact, the ethical rules at one point say in one of the comments, oh, lawyers in class actions have special obligations and responsibilities. The rules don't even tell you what that is. Why? Because our legal system, through statutes, through procedures, and most specifically through judicial oversight of the class process, and in fact also special obligations that courts take on in monitoring class actions. That is where we get, to some extent, the procedural sophistication to be able to deal with some of the nuances and difficulties that come up with class actions. So we heard this morning that class actions might be a form of capitalistic socialism. It's a totally new procedural regime. But what does it mean to take something as radical, as contested as it is 60 years later in our system, and drop it into a legal system where there might be some political instability, where the judges are not, they don't have the years of history, quite frankly, just the technical expertise to manage class actions. To me, it seems to me to create, again, this sort of ethical quicksand where the basic pillars of what a lawyer is supposed to do and how they're supposed to operate just can't be firmly founded. And finally, I'll end on one other point, which I thought a lot about how similar the Chevron case, how much it echoes to some extent we've already heard, the Dole and Nicaragua case, but also I think the Bhopal, India case, which is one that really fascinates me. I mean, the forum non-convenience dismissal is a sort of obvious lynch, but I think the ad hoc creation of a class action mechanism is another one. And the other point that I will highlight with this and many other forms of ATS litigation is that in all these instances where you have multinational corporations operating in developing countries, the government starts out as a joint venture partner. So you have that with Chevron and Petro Ecuador, you have that with Union Carbide in India, you have that with Unocal in Burma, you have that in all these different instances. But when the sort of political tide turns and all of a sudden a mass of their citizens are feeling vulnerable and potentially the financial implications turn, you see the government being the one that actually implements this new legislation to create a class action. And again, these are oftentimes situations, a political context where the notion of judicial independence is not so firmly entrenched that this government that might otherwise be liable in the action, okay, has nevertheless, in a sense, very wholeheartedly switched sides, created the mechanism, and its sort of dual role, again, I think creates a certain moral hazard that makes it very difficult and precarious for plaintiffs' counsel to find their way, as opposed to, for example, in the United States, where you have some of these very firmly drawn lines between the political situation and the judicial context for class action. So I couldn't possibly, as an academic, conclude without a few thoughts for the future. One is that I'm actually, I thought you did an awesome job, by the way, of outlining 8.5, but I do think it leaves a number of really important open questions and concerns, including it just really was not thought very well through, and I know some of the drafting history. They sort of threw in international it was only recently added that it applied not just to U.S. multi-jurisdictional cases, okay, or practice, but to multinational, multi-jurisdictional practice. Why is that so radically different? We'll take for a moment Donziger. If he were the sort of coordinating counsel in a multi-district U.S. Set of class actions that were filed, around the U.S., he would be on all the pleadings. He would be technically, in a sense, beholding to some of the courts. So 8.5 doesn't really, was sort of thrown in as an afterthought that it would apply transnationally. It definitely needs, I think, some revisions. I thought you did an excellent job of outlining what some of the problems with also parallel proceedings and how do you draw the lines. The other thing I will highlight is I do think that to some extent this is partially a generational and an educational problem. I used to teach transnational litigation. I used to always say, study hard, because when you get to a law firm, you will know way more than any of the partners. This was many years ago, because this wasn't taught in law schools 15, 20 years ago. So if you were a young lawyer starting out and you knew anything about transnational litigation, you necessarily knew more than the partners for whom you were working, which partially made me very interested in your center here, evidently trying to build competence in global class actions. That seems to me a very important thing. I will also add, as a final note of optimism, that I don't think it is impossible, even with profound ethical ambiguities about which rules apply, and opportunities for regulatory arbitrage that lawyers have in transnational litigations, in very profound ways. Because primarily where I operate is in a system called international litigation. Actually, it's probably not even properly called a system. And there we have a phenomenon called guerrilla tactics that people even write about. There's a whole genre of literature on guerrilla tactics. My favorite story is a faked car accident when an attorney was heading to a hearing in Russia, and then the opposing party went in and sent a sort of fake attorney to argue the case. There's another case of a kidnapped arbitrator that was kidnapped by one of the parties to disrupt the proceedings. These are really radical forms of misconduct. And in those instances, the response by the opposing counsel was not to sink to that level. And in large part, I think it is because the tribunals that exist in international arbitration, even if not formally courts, provide a sort of regulating mechanism. And more importantly, in terms of coming back to this issue of education and socialization, there are very strong social norms in the international arbitration community. And I think those operate to regulate in a way that has not taken hold yet in international litigation. So with that, I thank you. Also, I have to thank one more time our wonderful organizers. It's just been, I think, a tremendous conference. I've been so delighted to be here all day.
All right. Well, I was going to say we could ask questions of each other, but now with all the hands in the audience, maybe we'll turn to the hands and let our audience ask a few questions, and then if we have time, we can ask questions of each other. Deborah?
So each of you, with the possible exception of Patrick, focused on plaintiff's attorneys, and you in particular, Catherine, in the way you framed your comments. And the rationale for that intellectually was the concern about agency problems in the various circumstances you described. But I wanted to push at least Morris and Catherine on this point. So when I think about the relationship between lawyers and clients, I take on board the concerns that from the plaintiff side in mass litigation, and I think frankly it's a red herring whether it's a class action. I think this is an issue of aggregate litigation. In aggregate litigation, the lawyer is in charge for all the reasons that you talked about. When we think about the multinational corporation, it seems to me that maybe we're looking at the reverse situation with regard to power. The lawyer whose client is extremely powerful has enormous resources to engage in all these non-lawyerly activities, which clearly Chevron has done in this case. And the lawyer or law firm has considerable concern, and ever more so, in maintaining the relationship with this corporate client with regard to continuing litigation business. So could you say something about the ethical issues with regard to defense counsel?
So I think it's a great question. And I should say the reason I focused on the plaintiff's attorneys was not because I thought the agency problems were greater there than in other settings. I think it's a bit of a red herring, actually, to even distinguish aggregate litigation from some forms of non-aggregate litigation where the agency problems are equally severe. Nor was it because they wore the white hats, and so I was more offended by their conduct. It's just because, as I think Bert Newborn mentioned earlier today, the plaintiff's lawyers brought a videographer with them for years, and so we know, and then discovery proceedings in the United States led to production of all their internal emails and his diaries and their correspondence with each other and internal memoranda, and so I have this wonderful window into the plaintiff's side of the conduct that I do not have into Chevron's side, but all of my comments were equally applicable to both plaintiff's lawyers and defense lawyers in terms of the doctrinal work I did.
Yeah. I did intentionally focus on plaintiffs. I do think in this case one thing that's true is that there have been some allegations with regard to misconduct by defense counsel, including some I've spoken with journalists about. And interestingly enough, when the articles are written, they're not, what I think are serious issues. So one issue, that I thought was relatively troublesome, in part because lawyers have been disbarred by it, is there's a witness, Mr. Borges, who is apparently paid by checks written by a law firm where the memo line says witness fees, what is essentially, a monthly stipend, it looks like, plus, rental of an apartment. Paying an expert witness is not a problem, and if Chevron, as the client, were to hire him and say, congratulations, you're now a vice president, you have absolutely no responsibilities, that would be problematic, but it would not be unethical. Once the lawyers write the check and call it witness fees, I think it becomes very problematic. And in these types of contexts, one of the reasons why I highlighted at the end this joint venture and the slippage, so one of the areas where I think a lot of the conduct, if you started drilling down for defense counsel, happens is actually in the joint venture arrangement. So the case that comes to my mind is actually Rio Tinto in Papua New Guinea in Bougainville, where the counsel for Rio Tinto wrote a statute that was designed to preclude plaintiffs from ever filing an ATS case in the United States, and in fact, evidently, lawyers engaged in writing statutes for the company, for the country that they're sort of joint venture partners with. So yes, there's a lot of room, and I guess part of it is to some extent, I think that that conduct is already, I think, tends to happen. I'm not as well aware of it in the litigation stages, and it tends to happen earlier in the process and be part of the underlying claims, I would say, on the one hand, the conduct of defense counsel, and then, or counsel for the, at that time for the company. And then the second thing that I think, is at least worth thinking about is I do think, to the extent that there are issues of acculturation, to the extent that there are issues of experience and education, I do think it's easier, in a sense, for a multinational law firm to develop those internal norms, in part because they don't only represent a multinational corporation and they have something to lose. That's a little bit different in terms of what's at stake for their conduct if they were to try and, I think, be as creative or flexible in developing countries as, a plaintiff's counsel might be. And also, I think the other thing that's true is they have more of a track record, whereas I think a lot of the plaintiff's counsel, certainly Bhopal, I don't know Donziger personally well enough, but they go off and they're sort of these, accidental tourists, right? And there's a long history of attorneys on both sides getting arrested in Germany for trying to take a deposition or serve process when they're not allowed to. And I think that tends to be more for plaintiffs because it's their first venture abroad, whereas a big multinational law firm tends to have more multinational clients, and so it's less new to them. And they probably have more resources to find answers if they have questions along the way.
One question for Patrick and one for Morris. Patrick, yes, every fact is disputed, but don't we as journalists have an obligation to try to test those disputed facts for truth? My concern is that one of the lessons may be, no, 1,000 lies, if repeated, don't win in court, but they do win in the court of public opinion. And that's why I sometimes may come across as a madman. My question for Morris is, I love your reading of 8.5. I like how you applied it to the facts you stated, but those facts seem to me almost like a hypothetical, and such an incomplete description of this case as to be nothing more than a hypothetical, because even at the time of Patrick's article, it was clear that they not only engaged in ex parte context, but also ghost wrote a report put forward as independent by a court-appointed expert, which they represented every which way. Now we also have unanswered, overwhelming evidence of ghostwriting court orders, 9 different court orders, and at least close to a third of the final judgment, plus testimonial evidence that, in fact, they ghostwrote the entire final judgment, and all of that ghostwriting was, pursuant to bribes. So it seems to me that I don't know the Ecuadorian, ethical rules if they exist in any form, but surely that has to be sanctionable under any system. And moreover, I would suggest that maybe they ought to think about changing that ex parte rule.
They actually did.
Slope.
Just in the last few months.
Yeah. Okay. Sorry. Thanks.
Yeah, I mean, it should almost be self-evident, I hope, that yes, journalists do have a responsibility to try and weigh that. I mean, that was what I was doing in the article. And it was, I guess I was saying that as a journalist, my frustration is that you go in trying to write a 10,000-word, rigorously fact-checked account of what happened, and actually going down to Ecuador and talking to people on both sides, it becomes very difficult. I mean, there's a huge amount of innuendo. There's a great deal, I mean, and this, to some extent, to go to your point, there are, and you actually put it well earlier, there are sort of equal and opposite allegations of transgressions and impropriety in this case. But there's not really an equivalence in the sense that there's a huge body of evidence on one side that outweighs the evidence on the other side. Now, that doesn't necessarily mean that there isn't the same extent of impropriety on the other side. It means that I cannot confidently say there is. And what I found in talking to a whole bunch of people on the plaintiff's side is that whatever the truth about Chevron's conduct and Gibson Dunn's conduct, in Ecuador, I think all you need to do is read Steve Donziger's diary, which we can all do at this point, to know that he believed that there was an enormous amount of misconduct going on the part of Chevron in Ecuador. And for me, in thinking about him as a lawyer who had as I alluded to earlier, I think the kind of warp and woof of his personality have had an outsized impact on this case and all of these issues we're discussing. He believed at that time that he was in this asymmetric contest in which his adversary was cheating all over the place. Now, I cannot tell you that that was true or to what extent it may have been true or untrue. It does seem fairly clear that he believed it genuinely. And in trying to understand, struggling and often failing to understand what motivated him to do the things that he did and others on his team, I found at least a partial answer in the fact that there was that belief on their part that the rules were being broken by the guys on the other side. Can I substantiate that? Can they substantiate that? No. If you look at these, the emails that I mentioned earlier, I think you probably get them too. And there's always this kind of hyperbolic, bold-faced subject line, and then you read down, and sometimes there's something real there, and sometimes there's not.
The only thing I would add is you're absolutely right. I took a very soft version of the facts for purposes of applying the rule, using the facts that are contained in the various sources, including Patrick's article and Judge Kaplan's order, mostly as a hypothetical because I do not know exactly what happened. But I think you could have made a more extreme version that would have made the answers a lot easier to come to.
Thank you for your presentation. So I just wanted to clarify a bit, probably vindicate my Ecuadorian colleagues with respect to the ethical rules. I am aware of at least 3 points with respect to ethical rules that apply to lawyers in Ecuador, at least since 1969, and I'm sure there is an older version. There's a code of ethics that applies to all lawyers in Ecuador. And it's not probably as thorough as many of the ethical rules in the United States, but I would say that pretty much mimics many of the obligations. That's of course the law in the books. We know very little about the law in action, and that is a question that I have asked myself when I think about this case. In light of all these allegations, where are the actions being pursued? Because certainly both parties would have an interest in disqualifying counsel from the other side, or at least in exposing counsel from the other side. Number two, with respect to ethics, in late 2011, there was a bill brought to the Ecuadorian Congress, and I don't know whether I think the bill was never passed, to enjoin counsel from appearing in the media to talk about ongoing cases. And I don't think it was proposed, I don't know, probably on the surface it never looked as having any connection with this litigation, but having connection with something that has become very common in outside, all over the world, including some jurisdictions in the United States, where you have these radio shows or TV shows where lawyers are giving legal information or legal advice to people who have, a legal problem, and they will give that. So the Ecuadorian government is trying to do that, and lawyers, the bars are opposing this with the argument that this curtails freedom of speech and so on and so forth. Number three, there is a challenge now currently. It's waiting to be decided in the constitutional chamber of the Ecuadorian Supreme Court that is addressed to a code of judicial function. This is the 2009 statutes that consider lawyers, private lawyers in Ecuador, as officers of the court. And the bar associations have been trying to challenge this as well, because they say that they're not going to be able to work. Then I have another comment on class action. So there are no class actions in Ecuador, period. The U.S. court that dismissed the action based on forum none clarified that and actually gave plaintiffs an extra period of time to get organized. What has happened in Ecuador, which is very interesting, both from the from the standpoint of a strategy, and I'm going to talk about strategy later on, but also from the standpoint of ethics, is that plaintiffs proceeded as joinder. But because there's so many people, you have, 30,000 on Ecuador and then 25,000 on the Peruvian side, plus hundreds of thousands of people apparently affected by this disaster. Many associations were created. So the associations are the representative parties in the litigation. They are the parties to the litigation. The members of the association will likely benefit from the judgment, but there are no safeguards for them. So I think that's the interesting aspect here. What's really underneath the surface, not really what looks like this jungle place and with no rules and no lawyers and so on and so forth. Thank you.
I could clear up one back.
Others can correct me if I'm wrong, but I think what the legislation did in Ecuador was to make possible a suit for damages to the environment as opposed to personal injury and property injury claims, which is what Chevron was expecting when it went down there on a small basis. And Chevron argues that it was illegally retroactive.
Yeah, but there were essentially procedural innovations to mimic aggregate litigation or tort litigation that had not been, in a sense, proven and gone through a sort of vetting process, or they didn't have much experience with it. So it's a slightly different mechanism. It's definitely a different mechanism than class or aggregate litigation, but it's some of its purposes and some of the problems, I think, are quite parallel.
Catherine, I very much enjoyed your talk, but I had a question about your title. The bad guys are wearing the white hats. I'll overlook the fact that, in reality, virtually never does either side wear hats. I'm assuming you meant it figuratively. But I'm not sure why you're assuming ex ante in a litigation it's the plaintiff's lawyers who normally wear the white hats. If it's because they're suing on behalf of injured victims, well, that sort of begs the question of the litigation. If you mean that their behavior has traditionally been of a higher ethical quality than the defendants, I've been up against some plaintiffs' lawyers in asbestos and tobacco litigation. One of them is now in jail, who engaged in, some of whom engaged in totally reprehensible behavior. Obviously not all of them, but why do they have some ex-ante moral claim over the defense side? I mean, neither of these sides is Boy Scouts.
Yeah. No, I think that's a nice question. I mean, I think I was trying to play with the irony, which I think was raised in some of the earlier comments about, wait a minute, even if you know that there's a problem with the judgment and there's actually findings that there's problems, isn't it still righteous to try and enforce it because justice will be done if it's enforced? And I think unlike, I don't know, breast implant litigation or some other type of, when we hear about, there is a sort of intuition that I think goes with some of this ATS litigation. I think you're right about ex ante, and certainly it's been borne out in some of the cases where, there isn't much there in terms of the real claim. But I think there is an intuition. These cases read or sound like morality plays. It's almost like characters have been assigned, and that's part of what the white hat is from some spaghetti western, where someone is assigned a role by virtue of the color of their hat. And sort of my allusion to mustache twirlers, because when we hear about indigenous people, that's a very loaded term. When we hear about extractive industries and multinational corporations, those are also very loaded terms. I do think in our minds we put hats on them. And I think that's part of why it was so provocative to try and think about why, and to some extent, I guess we'll figure out, who are the bad guys, who are the good guys, who deserves to be wearing the white hats, who deserves to be wearing the black hats. Part of it I was taking as a starting point what I think is the sort of underlying morality play that we start with as a set of assumptions, and seeing that, factually it actually doesn't play out, and that's why they're, the sort of bad guys gets compared with the white hats. It's a working title. I may change it. You may have persuaded me. I'll think about it.
Very good. Do any of our panelists have questions for each other? I have one. Which is, so obviously the title of today's exercise is Lessons from the Chevron Ecuador Litigation. Mr. Boutros this morning went through the 10 lessons he thinks that we can learn from this litigation. From the perspectives you have, if you had to say, one lesson that comes out of this litigation, I mean, there's so much at this point that I think is still unclear. The litigation, is ongoing. Summary judgment motions are flying in New York. But from where we sit now, do you think there's a lesson that you feel confident that we can learn?
That's a great question.
It is a good question.
I'll take a stab at
Yeah.
it. So I gave a very doctrinal presentation, but I think at the end of the day, what we have here is not a doctrinal problem so much as a problem of professional identity. What does it mean to be a lawyer, and does our professional identity shift depending on the location in which we're engaged in conduct? Am I one kind of lawyer in California and another kind of lawyer in Ecuador? I think for me the lesson is I need to know who I am and what the core set of behaviors are that constitute my professional identity, and be true to that identity no matter where I practice, to avoid getting in precisely the kind of trouble that my law school classmate, Mr. Donziger, got in this particular case.
Did you want to?
Please.
Okay, I will actually. These were some thoughts I was thinking about. And didn't include in my talk, but I do think that there's a certain, and I think it goes for both defense and plaintiffs' counsel, a sort of legal cultural imperialism that's very tempting. Because I mean, one of the crown jewels of our legal system is our court system, and we are righteously very proud of it. But I do think it's problematic, and it happens both by our judges and our courts, as well as by attorneys, not understanding that, so I like the quote earlier, that our way of doing things, even if we're proud of it, isn't the only way of doing it. And I'll give a couple of examples that I think of this cultural legal imperialism. One is when attorneys sort of go abroad and don't even check what the local ethical rules are. They don't even care whether they're bound by their home rules or the local rules. They just are violating whatever because it somehow doesn't count in a foreign legal system. So, for example, the plaintiffs in the Bhopal, India disaster went and they were doing face-to-face solicitation. One person bragged that he was essentially signing up plaintiffs at a rate of 1 every 60 seconds in the first couple days after the disaster. These, consent forms were in languages that the plaintiffs didn't speak. I mean, this was just atrocious behavior under any circumstance, but they somehow felt liberated to go do it because it was this sort of greater good of getting them to U.S. justice. I also think our courts, and our rules of civil procedure do this a little bit. One is there are rules to have our courts authorize actually service abroad in violation of local law or discovery in violation of local law in a foreign system. I think that can be justified, but it's interesting because I think a lot of lawyers assume it should always happen if they're having trouble in a foreign system, and they should never have to just sort of defer to the fact that some things are not available to them in a foreign system. And I think I think part of this is going to be the growing interconnectedness of legal systems, which is already happening through transnational litigation and through alternatives like international arbitration, and the development, I think, through legal education when you have multicultural classrooms and you have exchanges. That greater awareness, I think, will end up developing international lawyers. So you won't just be a California lawyer who happens to go to Ecuador, but you'll be someone who's trained in California but has sort of international competence that you then bring to activities in foreign countries.
So yeah, I would just add, I guess one more, which is if I can speak it as the moderator. But I would say a lesson that comes to my mind is the be careful what you wish for, right? I mean, the two turning points in this case, which I think is so interesting, is when each side got what it wanted, right? So Chevron fought for almost a decade to get the case in Ecuador, and that turns out to look like something, the buyer's remorse from forum shopping. And then the plaintiffs wanted publicity, right? They really wanted sympathy. They wanted people to know the story. They got into Sundance, and they got the 600 hours of footage that is, haunting them as we speak. So, yeah, Bert.
I'm going to ask a question following up on Deborah's observation at the end of the first morning session, and that's that many of these, especially the transnational cases, but many of the cases are quasi-political issues that that occur in courts, and that the courts provide the matrix for what is usually a negotiated resolution of a very complicated matter in which law and politics and diplomacy and morality sort of merge. And because it's taking place in a court, there's an assumption that the strict judicial rules that would ordinarily apply in an ordinary one-on-one litigation apply here, and that's with ethics. So I wanted to push Morris. Morris wants to be the same person no matter where he is, you know. And let me say, Morris and I worked on the Holocaust cases together, and there was not a more important and a more productive lawyer in the place than Morris, and we owe him a tremendous debt. Can you be in the same place, two different lawyers? For example, I caught myself, and you'll remember this, when we were thinking about negotiating with the Swiss banks. We wanted to put pressure on those banks. Those banks had a tremendous leverage on us because they wouldn't let us in the books, their books. We didn't know what happened. The only way we could get in there was to frighten them. And the way some of the lawyers wanted to frighten them was to organize the controllers of the various cities in which there were large Jewish populations, and say that the controllers would go to the banks and say, you will never be lead counsel again in a municipal bond issue until this is resolved. Or the threat of a boycott of depositors, or the threat of, I don't know, whatever we could think of to threaten them. Now, I know you were troubled, and I was troubled at the edge as whether that's appropriate for lawyers to do. And yet, we didn't do it. Or if somebody didn't do it, I didn't do it. But if it wasn't done, I don't think we settled the case. And because the case itself was not a law case, the case itself was a complicated social issue that had resisted resolution for 2 generations, and now class actions provided a matrix within which it could be resolved, and we resolved it that way. But we weren't acting as pure lawyers while we were doing it. So
that's a great point. So the Holocaust litigation is a perfect example of a category of litigation where the court proceedings, though very time intensive and involving a lot of what we traditionally consider to be legal work, really were a placeholder for a political resolution ultimately that brought these settlements to bear, many of which were expressly political settlements negotiated by government-to-government negotiations in which we were mere interlopers and participants. But so the question you're asking is, can you be 2 people at once in the same category of litigation in the same jurisdiction? And I think the answer is yes, to a point, right? And so the second question I asked was, is there a point beyond which we cannot go? Is there a core set of values that we cannot violate under any set of circumstances? Change your hypothetical. We did, in the Holocaust cases, place pressure on the defendants using our political lobbying skills and our public relations skills, but we never attempted to place pressure on a judge. Right? It never crossed our minds to call the judge's credit card company and say, if the judge doesn't pay this month on time, jack the rates up 30%, or he can vote our way in the case. Those are the 2 choices, right? And the reason is because that would have been offensive to us whether we were in New York or in any other country in the world. There is some core set of values that we hold dear no matter where we are or no matter what hat that we're wearing. And I do think it's a difficult project to define exactly what those values are, but I do think it's a worthwhile project. And I don't think we ever lost that identity in that core set of professional values that constitutes our professional identity in the Holocaust cases.
Great answer.
Hi, I'm Stacey Strong, and I have a question that kind of comes from the international commercial arbitration milieu, because that's where I work most predominantly, and I know that Catherine obviously does a lot as well. And it seems to me that ICA has done a very good job in dealing with the cross-border cultural ethical issues in a way that I don't know that transnational litigation has quite grappled with as much. And so the two questions I would pose to the panel are, what should American lawyers do when our domestic ethical standards allow us to do things that are illegal elsewhere? The most predominant example of this, of course, is preparing witnesses and writing witness statements and doing those sorts of things. And the other issue, Catherine very, very presciently said that we need to become a global legal community. And there are a number of us, myself included, who are dual qualified. I'm a solicitor as well as a U.S. qualified lawyer. So this puts a burden on me with that exact issue, the preparation. And when I used to practice in London, I'd have to go back and forth, like, which hat am I in? Oh, I'm in arbitration, so it's okay. But can you talk a little bit about those pressures, which I think will grow on the coming generations of lawyers?
Well, I'll comment on one thing, which is just the astounding rate at which we are seeing, especially as law schools in the United States are grappling to make up for shortfalls in U.S. legal, law students. This, huge number of, and I forget what the percentages are. Someone here who remembers, of foreign lawyers getting licensed in New York. And they don't intend to practice in New York. They tend to go back and practice in their home country by and large, almost exclusively. But it raises some interesting 8.5 questions because they then are subject to 8.5, actually the quirky New York version of it. But so I think that to some extent these conflict issues are getting more and more complicated as you have multiple licensing situations and multiple appearances. I think one of the interesting things, and I'm not sure this is necessarily an answer to your question, but I think it's a nice thought experiment, especially as we're moving into some of the more, procedural complexities that are coming up. But, there are claims tribunals, a version of arbitration, are actually very effective at resolving when you have, mass number of people, and there's at least some sense that there might be some value that could be put in a pot and then divided up. And it's interesting because sometimes people say arbitration is less adversarial. I mean, they're multi-billion-dollar cases and they are fought tooth and nail. And in fact, there are some really tough tactics. But there is, I think it's somehow a sense of community or common enterprise that comes in that gives context to that adversarialism that is somehow different than when you have transnational litigation. But I think transnational litigation is evolving into its own genre, and as you start seeing firms that have repeat activities in these cases and track records to establish and reputations that they want to defend, you might start seeing some of that socialized into the practice regimes as well. It seems to have been slower on the plaintiff side, again, because I think it's just been a little more catch-as-catch-can for plaintiffs than for defense counsel.
The only thing I would add, it just sort of as a doctrinal matter, is as Catherine pointed out, it's not until 2002 that we even extended this choice of law provision under Model Rule 8.5 to tell us which rules apply in these kinds of situations. And there just isn't that much guidance. So I'm very sympathetic to the problem of the lawyer trying to figure out, when it comes to something very concrete, which set of rules governs in this situation. I teach ethics, so it's the first, we learn choice of law on the second day of class, right? Because to understand the law governing lawyers, the first question is, which law, right? So it's a tough question.
All right, well, let that be the last word. Thank you to Patrick Morris and Catherine.